Rohit, I really want to work with that company, but I feel like what if I work with that company, I share something very confidential and they end up sharing it with the world. What if they share my confidential information with the world? What would I do? For that, you got non-disclosure agreement. Like, what is non-disclosure agreement? Well, I'll tell you what non-disclosure agreement is and how to draft one. First of all, for starters, this non-disclosure agreement is a contract to not disclose the confidential information. While concluding this non-disclosure agreement, party negotiate on these 5 important clauses. Party negotiate on what confidential information would be, what it would include, what it would exclude, what is the tenure of this whole confidentiality norm, and what would be the penalty for the violation of this agreement. Now, before proceeding with the drafting of NDA, if you want this copy of NDA, you need to do 2 simple steps. First, you need to subscribe this channel and hit the bell icon. And second, you have to comment on this video that what you have learned after watching this video. After that, text me on my Instagram handle @LexVoti, and there I'll send you the document ASAP. Now let's draft the non-disclosure agreement. First of all, what we are going to do is to name the agreement, and that is non-disclosure agreement. Secondly, what we are going to do is to put what the effective date of this agreement would be, like from what date this agreement would be effective. Then you move forward and put the details of the parties. Usually, in most of the case, the parties are none but the companies. In that situation, apart from naming the company, you'd also need to put what their CIN number is, what their PAN number is. Why? To accurately identify them, who they are. Then we put the recital clause. Like, you would ask what recital clause is. Basically, in recital clause, we condense everything. Whenever anyone would read an agreement, if he or she is reading the recital clause, he would realize what this agreement is all about. You can see that in this agreement, the recital clause has 3 subclauses. What these clauses are: parties are intending to do something. Secondly, while doing something, they are going to share some confidential information. And thirdly, they are not going to disclose that confidential information with anybody else. Then what we are going to do, we are going to define what confidential information would be and what it would include. Now we move forward and define what it would exclude. Like, come on, there are many information that everybody knows. They can't mum you up, they can't zip you up that you can't disclose it to anybody else. Then there are many instances in which you have to disclose those confidential information forcibly, like the court order. Court is asking you to disclose some certain information, then you have to disclose it. And that's why on this clause you have to define a situation in which you would be allowed, you would be permitted to go and disclose such information. Then once you are done with the nuances of disclosure, you move forward and define what would be the tenure of this non-disclosure. Like, for how long you are not allowed to speak it up, for how long you are zipped up. For example, Tom Holland, he has signed an agreement with the Marvel that he is going to play the role of Spider-Man. And he's not going to tell anybody else that in the upcoming Spider-Man, if there would be any other Spider-Man, if there would be Tobey Maguire, if there would be Andrew Garfield, he's not allowed to speak it up. But how long? Once the movie is released, everybody would know. After that, he would be allowed to speak it up. And that is what tenure of non-disclosure clause would say. Now we come to the final substantial part of this agreement, that is representation and warranties. You would ask, what is representation and warranties? Let's abbreviate it as R&W. Here, the R, representation, means that a party is making some claims, party is making some statement. After hearing those claims, after hearing those statements, the other party is induced to enter into an agreement. Like, I am saying, bro, I got 10,000 rupees. Now, do you want to sell me this camera? And the other party think, okay, he got 10,000 rupees, and then I will counter propose that, okay, take this camera, I take your offer. So I induced him by giving my representation. Okay, that is representation. Then you would ask, what is warranty? Warranty is nothing but an assurance that what I'm representing, if it turns out to be false or a blatant lie, and if you suffer loss because of that, I am going to indemnify you. Now the rest 7 clauses are boilerplate clauses. Like, you would ask, what is boilerplate clauses? Basically, in every agreement, like in majority agreement, there are some certain clauses which are common to everyone. And that does not mean that you go to that agreement, copy it and paste it here. You can't copy and paste it. There would be consequence if you do that. You have to modify them accordingly. Now let's wrap it up quickly. First, indemnity clause. You share me the confidential information. I go outside, shout it out, let everyone know what that confidential information is. You suffer the loss, I will cover it up. Second, assignment clause. What it says that you are not allowed to assign the rights and obligation under this contract with anybody else. If you want to do that, you have to take written permission. Then comes the governing clause. Like, what it says, like, if your client is from USA, he won't want a law of North Korea to be placed for that agreement. Whatever he would want, you have to put it there. If he wants that the US laws would be applicable, you put that this agreement would be governed by the laws of the US. Then comes the severability clause. If one clause goes useless, that does not mean the whole agreement goes useless. Then comes the waiver clause. Mistake 1, strike 1. Mistake 2, strike 3. Basically, it means if my client have ignored what you have been doing since long, you have been breaching, you have been ignoring the terms of this agreement, it does not mean that my client have waived off its right. He still holds those rights and he could sue you in future if you again do that. Then comes the notice clause. Basically, if you want to give notice to the other party, you prescribe here the mode and how you would want to proceed with it, like how you would want to share the notices. Do you want to share the notices through email? You put it here. Then comes the entire agreement clause. What you are stating here is that this is the full agreement. Like this is it. If you want to go and determine the rights of the party, you have to read this agreement, not anything else. And that's it. And that was the basics of how to prepare an NDA, the non-disclosure agreement. I hope that this video gave some value to you. In case it did, hit the like button and share this video with your close friend who wants to understand the nuances of drafting the non-disclosure agreement. In case you want to see more such videos in future, hit the subscribe button. And thank you and happy Durga Puja.